Now we are going to discuss about the making sense of disqualification of Lok Sabha MP. Particularly the matter related to the Congress leader Rahul Gandhi. He was convicted on March 23, 2023. He was a former member of the parliament in Wayanad. He was convicted by the Judicial Magistrate Court in Surat, Gujarat. And the issuance of notification on next day by the Lok Sabha Secretariat Mr. Gandhi, disqualification raised some important constitutional and legal issues. The issue will anyway be dealt by the appellate court. He may go to further appellate in higher courts, but issues relating to disqualification need to be examined carefully. The Section 8 of the Representative of People Act 1951 RP Act simply is called as a RP Act, Representation of the People Act, specify the various offences conviction for which entail the disqualification of a member of a legislature. Class 3 of this section says that a person convicted of any offence other than those mentioned in the other two classes and sentenced not less than 2 years shall be disqualified from the date of conviction. Particularly note the date of conviction. However, class 4 has exempted the sitting member from the instant disqualification for 3 months to enable them to appeal against the conviction. This class was struck down by the Supreme Court in the case Lily Thomas versus Union of India 2013. So the effect of this judgment is that in instant disqualification of sitting legislature as soon as he is convicted. However, the court is made clear that the event of appellate court staying the conviction and sentence, the disqualification will be lifted and the member will be restored to him. The role of the President. Section 8 of 3 of RP Act, Representative of People Act 1951, which provides for the disqualification and conviction, has been subjected to judicial interpretation in number of cases. The surface view of the provision is that the moment of conviction and sentence are announced by the trial court, the member of legislature will stand disqualified. Upon such disqualification, his seat in a legislature fall vacant under Article 101(3)(a). But whenever we go to the closer reading, it reveals the word shall be disqualified used therein can't mean instant disqualification. If the word like shall stand disqualified were used in the class, they would be certainly mean to instant disqualification without intervention of any other authority. But here it's not there. The word used as a shall be disqualified only. So the passive voice used in this class implies that the person shall be disqualified by some authority. The writer says, under Article 103 source, the President of India is then authority. He only decides on the disqualification. There are two cases here, in particularly in Supreme Court. One, the Consumer Education and Research Society versus Union of India and Lily Thomas case. In these cases, the judgments refers the President performance educatory and declaratory functions here. There is no possibility to on his own views. But in Rahul Gandhi case, under section 8 of 4 RP 1951 Act, Lok Sabha issued the notification. So the opponent parties go to the Supreme Court. There was an example for that above restoration of membership. All of you know, the Lok Sabha MP was convicted up to 10 years for his attempt to murder case, and also he going to appeal in a higher court. The appellate jurisdiction give stay to the sentences and also the verdict of the lower court. So he applied to the Lok Sabha Secretariat for restore his membership.